So good morning, everyone, and welcome back to our weekly webinar series. Today, we are celebrating our 50th webinar, and I was more of confused that we should celebrate 50 or we should celebrate 54. 54 will be shortly because we will then be completing one full year of the process and the idea that every Saturday we will learn something new with all of you. Over to Anil sir, and we will take up the second part of the section 29 A analysis.
Thank you, Ankit. So, celebrating Golden Jubilee of AAA webinar series exactly started 50 weeks back, 1 week, 1 episode, and we have been able to do it without a break. As we said that, yes, thanks to all of you for giving us this motivation. Thanks to all the participants. Thanks to the kind of views that we get on our YouTube channel, although there is no commercial aspect into it, because this profession size is very small in India, and the contents of our webinars are not at all generating any YouTube revenue, because the YouTube revenue doesn't come for this small number of stakeholders. However, we are very happy to say that in the last 50 weeks, we have more than 18,000 participants. Maybe some of them are repeat, but all participants are basically the insolvency professionals, bankers, students, chartered accountants, company secretaries, advocates. In fact, there are many advocates who are actually regularly attending to our webinars. And so that's the motivation that we have. The scenario that we are going presently, as this, in case our health, our team has supported us. The advocates who have actually supported us is Shalya Agarwal, Amar Vivek, Aditya Gauri. They actually have been supporting us in preparing our contents. We both are guiding them, and the contents are prepared by them. Our technology person, Rohit Dubey, has also done a wonderful job. The team members who are preparing the PowerPoint presentation, at times we don't even get time to go through. But yes, what happened is right from this beginning, our morning is completely used for this endeavor, and getting up in the morning every Saturday at 5 o'clock and doing justice to this webinar series, that has become a habit. So Saturday morning till 12:15, we are not available any place, and not even for the family, because we are in fact doing all this research verification of the work done by the team members. That's what we've been doing. So Ankit, once again conveying our thanks to all the participants, and we can start this part two of our subject, that is the importance of section 29 capital A of IBC, and also practical aspects and judicial pronouncements. So in the last Saturday, the part one of this subject, we already have done kind of the various clauses of section 29 capital A, various amendments done, and each and every clause, what exactly it means, whether it is applicable to MSME or not, whether it is applicable to the connected persons or not. For each clause, there are different issues. So that we have handled in the part one. So today we would be discussing on how to verify the eligibility under section 29A for all the prospective resolution applicants, prospective bidders, or even for any proposer under Section 230 of the Companies Act. So the process is in fact very difficult, full of disclaimers. So we would actually be, the AAA is in a big way coming up in verification of 29A eligibility for all kinds of participants into resolution plan or bidding, or even the proposer for scheme under Section 230A. AAA has collected data. AAA has got the access to various public portals and other softwares where this information can be gathered. So we are in a big way verification of, because although we cannot do verification for our own cases, but we are now doing this verification for all other cases, whosoever approaches us for this part. So going through, I'll just share my PowerPoint presentation. Give me a second. So Ankit, we've done the first part of this. We'll actually directly we move on to the process of verification. So when we say the process of verification, although this PPT may not be sufficient for whatever I'm saying, I'm not reading PPT, I'm speaking out of my experience and whatever we've been doing for the last 6 years for verification of 29A. So the first process for verification is verify the resolution applicant or proposer. And then we are also trying to find out, first of all, the corporate debtor. We see the related parties to corporate debtor are defined under Section 524. Related parties to corporate debtor are defined under Section 524 of the IBC, and to individuals is defined IBC. So first of all, the RP or the liquidator must have the information about the related parties to the corporate debtor, related parties to the directors, related parties to the directors of the other companies who are connected companies. So the similar process that we have to adopt for all the prospective resolution applicants, prospective bidders, and then finally we can find out whether there is a ineligibility or not. Now the standing alone, in case we say 29A, all the first scenario that we do is the document that we ask all the PRAs and all the bidders to submit. That documents will include all these things: the list of company, main company, their directors, the companies in which the directors are directors. This list is supposed to be provided by all the PRAs and the bidders. Then while verification, we are also saying that you provide us the family members of the directors. And the family members of the directors are also defined under Section 524 capital A of the IBC. All that list of son, wife, relatives, all this you see very exhaustive list of relatives that has been covered by Section 5 subsection 24 capital A. That's what it is required from the list. So simply by taking the names from the PRAs or from the bidders, prospective bidders, that would not suffice. We need the PAN number and also DIN numbers for each relative of the prospective bidder and the prospective resolution applicants. So this is the information that we need from all these people. So in case anyone who is not providing this information, that actually would mean that we should not say that the person is eligible under Section 29A. That's the difficulty that we are facing nowadays. In fact, the PRAs or prospective bidders, they are not even sure at times the full names of their relatives as per the definition given in Section 524 capital A. And also they are not very sure at times what are their PAN numbers or what are their DIN number. They are not even sure whether they are filing returns. They are not even sometimes sure whether they are a director in a company or not, because this is something the families also are not sharing everything with their relatives. But then the second thing that we ask, and when affidavit, with that affidavit, we ask that yes, any PRA or prospective bidder should give an affidavit that they are eligible under Section 29A to participate into this process of this corporate debtor. So these two information, unless this comes from the prospective bidders or the prospective resolution applicants, one should not declare the list of eligible participants. Then comes is the verification part. And then there is another clause that we put in the detailed EOI or in the RFRP that in case, even after declaring the PRA or the prospective bidder as eligible, in case later on we find that the PRA or the prospective bidder was ineligible under Section 29A, maybe because of some information which comes to us later or because of some court proceedings, then in that case, the affidavit which was given by the PRA or the prospective bidder, that would be considered as incorrect affidavit. Therefore, their earnest money deposit would be forfeited. And the earnest money deposit would not be returned to them in case later on they would be held as ineligible under Section 29A. So these are the precautions. Now, when we start the process of verification at AAA, what we do is that we have complete access for verification of the details. However, the details that we verify, we use different kind of softwares for doing this. We also use the information available on the financial, the credit information bureaus. So there are 4 credit information bureaus which are authorized by the RBI. One is the TransUnion CIBIL, most commonly known as CIBIL. The second is Equifax, EQUIFAX, Equifax. Third is Experian. And the fourth is CRIF, CRIF, Highmark. So these are the 4 credit information bureaus as approved by RBI. Although the CIBIL is one, but the information can be sought from all the 4 websites. This information, some of the information is available free, some of the information is available on payment basis. Then we also go to the RBI list of willful defaulters. We also go to the SEBI, NSE, BSE lists of debarred parties. We also go to IBBI website for any kind of litigation on an insolvency account. We also go to NCLT, NCLAT websites to find out any case which is going on in the name of these parties. We also go to the litigation portals like Manupatra, and then we find the kind of litigations going on in the similar names. So the Ministry of Corporate Affairs also provides us the information about the disqualified directors. Now, Ankit, anything which is coming into your mind when you do this verification under Section 29A, like we are not trying to advertise any other software or any other stuff. We only should name anything which is available on public domain. But then, yes, we are using some softwares. And in case we name those software, that will be considered as the advertising those software. So we are not taking those names. But what are the other processes that is coming in your mind?
So the other processes are like, I strongly believe that a simple Google search where you write the name of the company and you also write the name of basically the RA normally can give you some result which which can be very, very different. Then there's certain words that you can use. You can say write the name of the entity and then say credit rating. Write of the name of the entity and then write default. Write in the name of the company and write NCLT. So the simple Google search with the correct search words can also give a lot of information sometimes. To the fact that in case you simply Google the address of the registered address of the company, you might find on Google itself many companies or many entities which are registered on the same registered address. So all these things are available publicly, and the software that you were mentioning are not doing something which a normal person can't. They are just using technology to gather all that information automatically rather than doing it manually. So those softwares will say that, okay, if the email address or email domain is common, let's say there's a group entity or a group which uses @ of xyz.com, then if that is the domain name that is used for another entity, then that can establish a very strong relationship between the two entities. And in a very recent case, this was exactly the reason why we were able to identify and say that these two parties seem to be related, because the GST registration of a proprietorship concern had the domain name of the CD itself. So it's pretty vast, and I think we kind of keep innovating this, and it's the process that you follow which is rather has to be complete, has to be done by somebody who has the experience on doing this, and one of course has to have that kind of mindset to keep looking and kind of keep looking for the right clues to find any relationship.
So you're very right, Ankit, that the softwares that we are using, they can find even the related parties based on the common email ID, common domain name, common employees, common address, and even past employees, even past directors. So these are the kind of softwares that we are using for verification under Section 29A. So that is the process that we feel is very important, because see, the ultimate responsibility of verification of 29A lies with the RP or the liquidator. COC is not responsible, and COC has no power to say that this person is eligible and this person is not eligible. The only thing is that the RP only for the sake of being transparent is sharing everything with the committee of creditors, and so that the transparency is maintained. Otherwise, the committee of creditors is not responsible. If someone who is not eligible is declared as eligible, the responsibility lies with the RP. And the IBBI will definitely say that it is your responsibility. You can't even say later on that I shared the list of eligible candidates with the COC, and the COC never objected to it. You can't even say that the other eligible candidates, they never objected it. You can't even say that the affidavit was taken. You can't even say that the clauses were answered where their EMD would be forfeited. The RP is responsible for identifying a person who is eligible, who is not eligible, and that is not something which you can transfer or shift just because you did not do your job or information. However, there are disclaimers. Now, in case a particular person is, in case any application is filed for insolvency of a company, that particular information would not come on the public domain unless the listing is done. Then only it will come on NCLT website. Secondly, if a person is declared as NPA, that information doesn't come on any public domain. Simply a bank takes a decision that this particular account is NPA, and maybe that the bank also takes a decision that it is from the back date. But that information would not come on the public domain unless some litigation starts either before DRT or before IBBI. So if some kind of arrangement or some kind of one-time settlement or some kind of restructuring is going on with the bank, that also information is not available on the public domain except on the CIBIL. So the verification of CIBIL kind of credit information bureaus, that is very, very important for finding NPAs. So this is then IBBI website that we verify, and then we also go to the websites of the tribunal, High Court, Supreme Court, Debt Recovery Tribunal. So there are actually softwares that we use which actually can provide us the litigation details about a company even for the last 15 years. Even all those cases which are disposed of, that also will come to know. These kind of softwares that we are using. NSC, India.com, similarly BSC, similarly like disqualified directors which are on MCA website. So these are various scenarios. However, whenever the reports are given or whenever the eligibility, the list of eligibility PRAs or eligible prospective bidders is given, I think that should be given with some disclaimers that the RP or any of the consultant doesn't have access to recently classified as NPA accounts. Similarly, the gap between the actual decision by the authorities and the information going to public domain, that gap is also a disclaimer. Any other disclaimer which comes to your mind, Ankit? Because see, these reports, you are making these reports, and what are the disclaimers that you feel that which is actually we have no way to find out the solution for those gaps? What are the other disclaimers?
So my thought process there is that, as you said earlier, also the responsibility lies with the RP. So even when we are acting as valuers, when we are acting as forensic auditors or transaction auditors, when we are acting as 29A, in that capacity, whenever we are doing work for any RP, I sometimes feel that our effort is limited by way of the information availability and the information which is available in public domain. And that's the biggest disclaimer, that whatever reports one can make is based on the information available. So in case of a transaction audit where the books of accounts itself are not available, the transaction audit will be very, very shallow audit, or rather there will be almost no audit. But what I'm trying to say here is that it can also be possible for a professional to not knowing about these sources of information which are available, and therefore a comprehensive scope of work to the professionals that are being appointed, giving them a proper scope of work, that these are the databases that you will look into to determine 29A compliance, might be important for RPs. Secondly, report verification, because the onus here lies with the RP. Even if the RP has appointed a third-party agency, it only provides part comfort or other part justification on part of the RP that he appointed a professional to do this compliance, but the end responsibility still lies with the RP. So therefore, it is important to check that report whenever that comes and make sure that it seems to be a complete report, and the professional has duly done all the processes that were done. And the screenshots of the processes done by the professional should ideally be part of the report. If they are not part of the report and the report simply says that, yes, this was done, this was done, this was done, then maybe there is, the report can be a better report.
So like we have seen some of the people, they are giving reports in the market and they are simply saying that there is no, everyone is eligible under section 29A, and that reports finally gives no source of information, no efforts made. The report that I have seen, and we have spent money on that, that only comprises of the details of the corporate data, details of the related parties, and then a chart which says that no, under all clauses of, under all the 10 clauses of 29A. So they would say no connected, no ineligibility found. And no detail of efforts made, no details of the information accessed, no details and of the evidence is also attached. So these kind of reports, I believe, is just money making game, and it actually is not getting into the real objective of this scenario. However, we are now going to the judicial pronouncement where this connected person definition has actually been diluted, one that we've already said in the last part one, that in some of the clauses, connected persons, if that clause is applicable to connected persons, that is not considered to be ineligibility, because that particular clause is applicable only to the resolution applicant and not to the connected persons. So there are clauses in section 29 capital A. Now, when we move on to the judicial pronouncements, we'll start with the Supreme Court judgments, and the first judgment that comes across to our radar is the Bank of Baroda and others versus MBL Infrastructure Limited. This was a judgment given by Honorable Supreme Court on 18th January 22, and Justice Sanjay Kishan Kaul and Justice M.M. Sundaresh was the honorable judges here. The basic scope which and basic issues which was decided by this judgment, whether the scope and the interpretation of Section 29 capital A, and that was specifically the clause H, which was regarding the guarantee, personal guarantee, and the guarantee given to the other to secure the loan. Whether the personal guarantor is barred only in cases where the guarantee executed in favor of the creditor has invoked the guarantee before the commencement of CIRP. This was the basic issue. So in this case, the respondent number one is the company, and the director of the company the loan was taken, and the few banks in the consortium, they invoked the personal guarantee of the directors. Now, when the personal guarantee of the directors were invoked, and the company went for CIRP, and the two resolution plans were received. One was by the director of the company, the director of the company whose guarantee was invoked. And this was invoked even prior to insertion of Section 29 capital A in the IBC. So at that time, there was ambiguity in the situation. So the director, in fact, filed an application before NCLT, playing for a declaration that he is eligible for submitting the proposal under Section 29 capital A, C, and H, which came out to be the that was basically coming out to the in favor of the guarantor, because this was so. The NCLT, in fact, sanctioned the resolution plan of the director, and the director whose guarantee was invoked, and that guarantee remained unpaid. That resolution plan was approved by NCLT, and appeal was also filed before NCLT, and the same was also rejected because the resolution plan was approved by the COC with 78%. So both these, like NCLT and NCLT, these judgments came before the Honorable Supreme Court, and the Honorable Supreme Court held in this case, placing reliance on ABIX Singapore Private Limited versus COC of Educom, to hold that the COC in approving the resolution plan shall take into account the feasibility and viability of the plan and the order of distribution under Section 53(1) of the IBC, and the COC cannot sanction a resolution plan barred under Section 29A. So the apex court in this case admitted and held that NCLT and NCLAT was incorrect in their decisions, having considering the commercial wisdom of the COC. So the commercial wisdom of the COC cannot be extended to the eligibility of the applicant under Section 29A. This was very, very clear by the Supreme Court. And in this case, the creditor, the director of the company whose guarantee was invoked and remained unpaid, and that was even before the amendment in the law, that particular director was held as barred under Section 29A, capital the clause H, for submitting a resolution plan. So, Ankit, anything that you think about this, which is the Bank of Baroda versus MBL infrastructure? It is only restricted to the guarantors, and the judgment also, like there is a slightly, like, it is not saying that the 29A is retrospective, but it is saying that the person was not eligible.
I think the thought process, I think this is one of the earlier judgments where the whole idea that COC can decide, or what are the powers of the COC to kind of override 29A, or rather, disregard 29A were discussed. So I think it's very clear that the law prohibits any transfer to any 29A non-compliant person. And that is, I think, that was also extended later, if I remember correctly, when the law was amended to say that the COC cannot even decide to pass on the asset to a 29A non-compliant person in the event of liquidation. Because once the CIRP was blocked, then for the COC to hand over the asset to a 29A non-compliant person, that the COC was often finding higher value being paid or being offered by those who were non-compliant under 29A under liquidation. So I think even that is barred later through an amendment. So it's very
Yes.
clear.
See, we move on to Ankit Arun Kumar Jagat Ramka versus Jindal Steel and Power Limited. In this case, this was a judgment in 15th of March 21. Justice D.Y. Chandrachud, who is the Chief Justice of India today, and Justice Mukesh Kumar Rishik Bhai Shah. So this judgment was primarily focused on whether this 29A is also applicable on a scheme of compromise and arrangement under Section 230 of the Companies Act. So this judgment was very popular, the Arun Kumar Jagat Ramka, and this was the Gujarat NRE Coke. That case was a very, very popular case, and whether the regulation 2B of the liquidation process regulation, which was inserted later on, whether that was constitutional or not. So this finally judgment went to the Honorable Supreme Court, and the Supreme Court held that yes, Section 29A eligibility is required for any proposer under Section 230 of the Companies Act for any scheme of compromise or arrangement. So in this particular case, first when this Section 29A was inserted at that time, the Arun Kumar Jagat Ramka was also a resolution applicant through any company or through himself. But then he was eligible, he was held as ineligible when the Section 29A. Then the company went into liquidation, and in the liquidation, he also proposed to submit a scheme. He proposed a scheme of compromise. So it was very clearly held, and the Supreme Court dismissed the appeal, and it is further stated that prohibition placed by the Parliament in Section 29 capital A and Section 35(1)(f) clause F, because see, a proviso was added, Ankit, in Section 35(1), which is the duties of the liquidator, and one of the duty of the liquidator is to sell the assets of the corporate debtor. However, a proviso was added in there that the liquidator would not be able to sell any asset to any person who is not eligible to submit a resolution plan in that case. So that was also held as constitutional. Going forward, we have this also very, very popular judgment like ArcelorMittal India Private Limited versus Satish Kumar Gupta, and judgment came on 4th of October.
So before we take it up, we can take up some questions. Lots of questions. Maybe we can take a little some of the questions. So if is CD, who there's a question from Sanjay Sumadraji, was asking, is CD, who is an MSME, are exempted from 29A, and can he give net worth certificate of third party who is party along with him in submitting resolution plan and CIRP process? So joint submission of the resolution plan might be allowed in the EOI, depends on how that is structured. Normally it is allowed. With respect to exempted under 29A, the exemption is with respect to the NPA, and there is specific assumption in 29A on the MSME companies, right? So that's what maybe you can add further.
No, I still, because there's some noise here, in case you can repeat.
So is the CD
Yes, Ankit.
Is the CD, who is an MSME, are exempted from Section 29A? So basically, we're talking about MSME CDs. That is the question, that what is the special provision for them? And the second question is that if the CD, who is an MSME, does not have the net worth, or rather maybe the promoters do not have the net worth, can then, in that case, can there be a party along with the promoters who can then jointly submit the resolution plan? This is the question.
So first of all, the Section 240 capital A was inserted in IBC, where the exemption was granted to MSME segment of corporate debtors. For any corporate debtor which is MSME based on the Udyam certificate, that particular corporate debtor, two clauses of Section 29A is not applicable. One is clause C and the other is clause H. Now, clause C is regarding the NPA account, and clause H is regarding the grantee which remained unpaid. So this any company which is MSME, for that particular company, for any resolution applicant, the clause C and clause H is not applicable. Now, secondly, what you are saying is that in case the promoter is not having the net worth or promoter is not having the eligibility criteria as mentioned in the detailed EOI or RFRP, then in that case, any other person can join the promoters. Any other person can join the promoters, but the eligibility under section 29A would be applicable to both promoters as well as to the other person. Now, let me very clearly say that when this corporate debtor is a MSME, then this particular assumption of clause C and H is simply not applicable to promoters. It is applicable to everyone. Yes, Ankit.
So then we have a question that when there is a settlement under 12A, will 29A apply? I don't think it applies in that
No, it
case.
doesn't apply.
Yes. Then we have a question which says whether COC is also responsible for checking the eligibility of 29A. I think this was answered that COC is not responsible. It is the responsibility of the RP.
But the COC has got no power. COC is under responsible. COC definitely should see the work done by the RP. COC should definitely direct the RP to do this work. But the COC cannot say without any rationale that this person is eligible and this person is not eligible. There is a judgment that we will just read when we finish the question answers.
We have a question, not sure what the name is, but how the promoters whose account has been declared as NP and CRP is going on will be eligible to submit the resolution plan. So I think we've talked about that within 1 year of NPA, there is an eligibility. And of course, MSME is a waiver.
For the promoters, there is a waiver if MSME is there.
Yes, MSME, and secondly, if NPA is within 1 year.
Yes.
Two things that are changed, that are different there. Then we have a question, does SEBI provide any information of borrowers whose accounts are NPA with various banks?
SEBI doesn't provide this information. And SEBI is only applicable to listed companies. For unlisted companies or LLPs, the SEBI is not at all.
So it does not ensure completeness in any case, even if SEBI would have done that. RAs are punished by way of forfeiting the EMD if unknowingly one of the relative is covered by 29A. So that's why it's that's why it's very, very important that before we submit the EMD as any RA, then we need to disclose that, yes, this is how our structure is. And if there is any relative who is maybe a distant relative who is having a non-compliance with 29A, then coming to know about that and disclosing that in your resolution, in your disclosure will perhaps be a better idea.
No, I think there is an exception now, which is based on the judicial pronouncements and more specific to the specific Swiss Ribbons Private Limited judgment of Honorable Supreme Court. The Honorable Supreme Court has held that any relative, if he is not doing business with you, he would not be considered as a connected person. So if a person is doing business with you, then you are supposed to have all this information for your partners or any person that you are doing business with. However, in case there is any relative who is not doing business with you or with any of your associate concern or with the corporate debtor, so that is corporate debtor is wrong. So that is not considered as connected person. I mean, I think in the part 1 I said that now the Mukesh Ambani is taking over the companies which were promoted by Anil Ambani. And that is the only judgment which is being used for taking over such companies. Otherwise, in case we clearly read section 29A, the definition of connected persons, then Mukesh Ambani will become ineligible to participate into any acquisition under IBC because his real brother is NPA. So therefore, the Swiss Ribbons judgment Supreme Court has held that any relative not doing business with you would not be considered as connected person.
So that's there, but then what I'm trying to say is that in case there's a disclosure about the idea that yes, this person is my relative, and either you disclose and say that this person is my relative, but I do not have any business connection with this person, and therefore I'm compliant with 29A. Alternatively, you say that, yes, this person is my relative. He is non-compliant for 29A and he is not having a business connection with me. Therefore, I'm still compliant with 29A. This kind of disclosure at the time of making the resolution plan is a better idea rather than litigating on the fact that this disclosure was not made and therefore an eligibility under 29A was found later.
Yes. We can go to the next questions.
So, so if in other words, applicant can withdraw the CIRP application even during liquidation, and if the CD settles the creditors under 230 of the company law as an OTS, then 29A will not hit. So now the next question is, will 230 still require a 29A compliance? I think it also applies.
No, 230, I've already said this. Arun Kumar Jagatram ka versus Jindal, that's a complete judgment of Honorable Supreme Court, where it has been held that any proposer under Section 230 of the Companies Act would have to be eligible under Section 29A to submit a resolution plan.
Exactly. So then the question is, how some agencies who provide 29A verification services do the verification? What are the, I think that's already answered. Does the NESL provide the verification of RA? No, I don't think they do. No, NESL does not provide.
But that's another source of information nowadays for, because see, the information utilities are, now the role of information utilities will actually increase once the proposed amendments as per the notice of MCA dated 18th of January 2023. Once those proposed amendments will become law of the land, then the utility, the information utility will have a lot of increased importance, and then the data would flow in. That data would be used for even verification under Section 29A regarding defaults.
So forfeited EMD of ineligible PRAs can be used for CIRP cost, or it can also be distributed to creditors? That's a question.
I see the only thing that I would like to say, any kind of income forfeiture or any collection from the debtor,
it is available to the CD.
It has to, it belongs to the company, and whatever money belongs to the company, that can be utilized for CIRP cost, liquidation cost, or distribution to the creditors.
Right.
We can
Let's move on. Let's move on to the next question. The next topic. Yeah. Next judgment.
Okay, going ahead with the, like, this is a very, very old judgment, ArcelorMittal India Private Limited versus Satish Kumar Gupta, dated 4th of October 2018, and before the retirement of Justice R.F. Nariman. So this judgment was, in fact, whether the resolution plan submitted by AMIL and New Metal was violative of Section 29A. So in this case, see, like basically, this was the judgment in the case of SR Steel India Limited, and the this ArcelorMittal was one of the appellant, and New Metal submitted their resolution plans. However, the resolution professional found that the appellant and New Metal to be ineligible under Section 29A of the IBC. How? ArcelorMittal Netherlands, AM and Netherlands, shown as a connected person of appellant in the resolution plan, has been disclosed as the promoter of Uttam Galva Steel. So ArcelorMittal was shown as a connected person. Now the connected person is also shown as the promoter of Uttam Galva, and the Uttam Galva's account was NPA. Therefore, in the case of SR Steel, the ArcelorMittal was held as the ineligible under Section 29A. However, the Supreme Court in this case, specifically on the request of SR Steel and the COC, on the special request of COC, used a special powers under Article 142 of the Constitution, and granted one more opportunity to ArcelorMittal to pay off the NPA account of Uttam Galva, and then within 2 weeks, and then their resolution plan will be considered. That was a one-time kind of relief given to them, and that was long back. I don't see any usage of this Article 142, because that was one-time usage. Presently, in case anyone would be found as the related party and also ineligible, that resolution plan would be rejected. Coming to a very, very important judgment is Swiss Ribbons Private Limited versus Union of India, and various questions regarding constitution, validity and everything. This was also a beautiful judgment given by Justice R.F. Nariman and Justice Naveen Sinha. And in this case, the various constitutional legitimacy and this was all under section like 7, 12A, 29A, and 53, all actually had gone through the test of the constitutionality or not. So in the relevant part, which is applicable to section 29A, one that it was prospective and it was constitutionally valid, it was not retrospective. This various things we held by this particular judgment was that this section is arbitrary because imposes a blanket ban on all promoters and lumps both unethical and honest promoters together. Now, this was being argued before the Honorable Supreme Court that this section 29A is actually making treating both unethical and honest promoters in a lump and not distinguishing between the honest and fraudulent promoters. And this particular argument was not accepted by the Supreme Court. Excluding a person who is unable to service his own debts from offering a settlement plan, according to the court, is quite reasonable, because see, like a person who is NPA, even if ethical or honest, doesn't mean that the person who is not even able to pay his own debt would be able to acquire another company. The maximization definitely is the purpose, and section 29A is incompatible with that purpose. That was also one of the argument, because it was found and it was held that the promoters can offer the best value for a particular company because they know the facts more than anyone else. Now, finally, the most important part was that furthermore, in response to the contention that relatives are ineligible, the Supreme Court stated that section 29A(j) prohibits relatives from participating unless they have a business tie with the resolution applicant. So it is not really correct to say that all relatives, only those relatives would be considered as connected people who are actually having some business tie. In this matter also held that this section 240A, which is inserted for giving a relief to MSME segment. So it was held that only clause C and clause H is exempted. All other clauses are also applicable to all those cases which are even MSME. And only exemption is for clause C and clause H of 29A. Now there are some judgments which we actually will take up quickly, Ankit. This judgment from NCLAT, the Gambar Anand Rao Pingal, shareholders of Messrs. Pingal Builders Private Limited. This was the judgment versus Shrikant Madanlal Jawar, the name of the RP in the case of Pingal Builders. The judgment is in July 21. The issue in this case was whether the former director promoter after initiation of CIRP can apply for MSME certificate and tide over ineligibility. So in this particular case, even after the CIRP started, when the powers of the board of directors were suspended, the promoter director made an application for MSME registration under his signature without coming to RP, without even coming to COC, and got this registration done in the Udyam registration portal. NCLAT said in this case that this is not a valid step taken by the promoter even if the company is now registered under Udyam registration portal, but this registration was done by the promoter without seeking any approval, so that will not be considered as valid registration. Therefore, the promoter would be still considered as ineligible because of this non-compliance. So that's like one NCLAT judgment. I've just given you the brief, and the other is Avantha Holdings Limited versus Abhilash Lal, the resolution professional for Jabua Power. Since you have done the Jabua Power's it was July 22. So it was, this particular judgment is still pending before Honorable Supreme Court. So we cannot consider that this judgment is actually, this judgment is presently valid. But then yes, as till the time the Supreme Court decides. Now, in this particular case, what happened is the joint venture, there was a joint venture, like the Canara Bank classified a joint venture of NTPC as an NPA. Joint venture of NTPC as NPA. And NTPC was a resolution applicant in this case. So one of the joint venture was classified as NPA. The classification was done on 21st of May 2018. However, it was made effective from 1st April 2009, like 9 years earlier. So the effectiveness was effective 9 years back. Now, since the NTPC was promoter of that joint venture, so therefore the NTPC became under Section 29A(c) based on the qualification as NPA for that joint venture. Now, in this case, the appellant said that there is no disqualification attached to NTPC under Section 29A. Respondent submitted that the COC has duly considered the settlement proposal submitted by the appellant under Section 12A and found the same as unacceptable. Now, the NCLAT in this case says that the statutory provisions under Section 29A of the code has given a grace period of 1 year, and in case even after the expiry of the grace period, the resolution applicant is unable to pay its dues and continues as NPA, then the resolution applicant becomes ineligible. Then NCLAT further held that the date of NPA classification ought to be taken as 21st of May 2018, and then the back date cannot be considered for any purpose. So since the 1 year has not elapsed from the date of NPA, because see, from 21st of May 2018 and the date on which the resolution plan was submitted by NTPC, so that particular, there was not, the gap was not more than a year. So therefore, the RA was eligible. However, this matter is pending before the court. So in case within 1 year of the NPA, then the can be eligible, further can still be eligible. Going further, Everest Organics Limited versus Lisa Life Sciences Private Limited, represented by RP Mr. Jagadish Kumar Muri. So this judge is January 22, and in this judgment, the only issue, which is a very, very small issue, whether the COC has the power to consider the ineligibility or eligibility of a resolution applicant under Section 29A, any of the clauses. So in this case, it was basically the COC wanted particular, the SBI was the COC lead bank, and the SBI decided without any basis that the respondent number 3 is a qualified under Section 29A of the code in the meeting held by COC. Now it was argued that COC has no power to consider the ineligibility of the respondent number 3 under 29A. The counsels, in fact, they said that the corporate have submitted their resolution plans pursuant to the expression of interest issued by the RP. Now, in this case, NCLT held that the code and the regulation empowered the COC of approving the resolution plans and empowers that it shall not approve a resolution plan where the RA is ineligible under Section 29. COC has power to take a decision with regard to approval of the resolution plan and not to decide about the eligibility of the applicant. Committee has also the power to evaluate the resolution plan. The committee has power to approve a resolution plan, and however, the committee has power to approve the resolution, can consider the eligibility and ineligibility, but it doesn't mean that the committee has any power to overstep the provisions of Section 29A. Even if Section 29A says that this person is ineligible, the COC has no power to say that the person is eligible. Any comment from your side, Ankit, on these few judgments?
I think that's it. That's good. I think we need to close it. We only have 5 more minutes.
Martin S.K. Gola, erstwhile RP versus Wig Brothers, Wig Associate. And this is also like a section, it was a retrospective effect or not. Section 29A of the IBC will be applicable with a retrospective effect in Section 10 proceedings that were initiated prior to Section 29A coming into force. So the respondent initiated the CIRP against itself. So then finally, so this was also a very, very kind of the judgment was, I'll just only go through the held part. So the resolution plan it was rejected, and one thing which was very clear to say that this subsequent introduction of Section 240A of the IBC and subsequent taking of a certificate of being MSME will not cure the ineligibility at the time of submitting an OTS cum resolution plan. So in this case, first of all, an OTS was submitted. It was only one lender, COC. Then when this Section 240A came, then that particular OTS was converted into a resolution plan. The resolution plan was submitted to NCLT and saying that this was not the Section 240 has been inserted now. So the OTS was considered to be submitted before even the insertion of Section 240A for MSME. So court has held finally that the OTS, when it was submitted, that was the time when the law was applicable. So the law at that time was not giving any exemption to MSME. So therefore, the OTS was converted into a resolution plan very clearly cannot be accepted. Kanti Mohan Rastagi versus Red Brick Consulting Private Limited. This judgment is as latest as 6th of February 23. So in an auction process, the purchaser is an MSME and the purchaser is trying to claim the benefit of Section 240A, and that's the case in this case. So this was also a case where the Udyam registration was not produced. Once the Udyam registration was not produced, the benefit under Section 240A was declined. That is, in short, that's the only thing that we have for today. As far as the judicial pronouncements are concerned, Ankit, can you see that some of the questions are there? You are not.
I can see that. It says that one of the questions is that so the date of submission of resolution plan by SRA assumes importance, and within 1 year he has to make good of the NPA account and not 1 year from the date of NPA. This is the interpretation that is being sought as confirmation.
I think from the date of declaration, this is not that what we said. So when a bank classify an account as NPA, that is called the date of classification. Now, mostly the bank says that today we are classifying this account as NPA. However, the effective date of the NPA would be something in the past. So the judgment says that the declaration date is important, not the effective date. If I have no information about what is in the mind of the bank, so all my actions will not actually go to that side. Today, bank has declared it as NPA. effective date may be 10 years before. From today's date, if 1 year has not lapsed, from today's date, if 1 year has not lapsed, then eligibility would be given under section 29A. That's what the judgment was.
So there's a question that says that Ravi ji is asking this question, that in case of bidder, should the CD be MSME or the bidder be MSME? So the exemption is on the bidder to be the MSME, or rather
the exemption is on the CD to be MSME, not on the bidder.
So the CD is an MSME. In that case, the bidder can bid for the company, and the bidder can be anyone. The bidder need not be an
exemption of
MSME.
section 240A is on the CD.
CD should be a MSME.
CD should be MSME. The CD should have the Udyam registration, and that registration should not have been taken by the promoters without any approval from the RP or the COC. So, however, the COC or the RP can apply for MSME registration during CIRP, even if it was not available earlier. The benefit of section 240A of MSME can be denied if the Udyam registration is not there. So this Udyam registration cannot be effective retrospectively. Section 29A cannot be effective retrospectively. So these are some of the judicial pronouncements that we have said. And also very important, if we are not doing business together, then even our relatives are also not connected people.
So Ratish ji from Union Bank is asking if, of course, I think you've already answered the idea that Udyam certificate is the mandatory requirement to say that the CD is an MSME. Yes. That's something that is established. Is it also established? Manish ji was asking with respect to how a related party, if it can establish that it has no business connection with the relative or with the person who is causing the disqualification under 29A, then they can be a permitted resolution applicant.
Absolutely, absolutely.
That's also covered up. So one request that has come in, that there is a request that can you please conduct a webinar on steps to be taken by the RA after the plan is approved by NCLT and the CD is taken over. So this is
very important, very, very important. You have taken my heart, and in fact, I have already given a message yesterday to my team that our next webinar would be on this subject, because we have seen, in fact, I went to Kolkata for implementation of a resolution plan and also implementation of a sale of the company as a going concern during liquidation process. I actually find that the resolution applicant was finding a lot of difficulties. So we need to list all that. We need to educate our colleagues on this. We'll be conducting this webinar next week.
There's also this judgment which somebody wants feedback on, that is Siva Industries and Holdings case of SC 2022 judgment. We can get back on this after studying this judgment if this is something important. This was where the Apex Court quashed the NCLAT order for liquidation of Siva Industries. So we can go through this judgment and see in case there is any important interpretation in this that we can share with everyone.
Yeah.
So that's about it. Those were the questions. And thank you everyone for joining us and being part of this journey to the 50th webinar. And I think the next, the next goal should be 100 and then keep going. So we'll continue that effort.
Thank you very much, participants. Cheers to all for Golden Jubilee celebrations of AAA webinar series. Thank you. We concluded 50th episode today. Thank you.